Hello, and thank you for joining us for the SLW Institute webinar, Using Examiner Analytics to Improve Prosecution Efficiency and Develop Well-Informed, Data-Driven Prosecution Decisions and Strategy. This is the fourth episode of an 8-part series about patent analytics. Feel free to enter any questions in the Q&A feature of the Zoom menu. A recording of the webinar and the slides will be emailed to all registrants. And with that, I'll hand things over to Steve.
Thank you, Michelle, and welcome everybody to our latest webinar. Today we've got some return panelists, and we've got a new panelist. I'll start with our new panelist, who's Garrett Hall, who's a principal at Schwegman, Lundberg, Worcester. Garrett is a highly experienced patent prosecutor and uses examiner analytics on a routine basis in his practice. So we're looking forward to hearing how he uses them and what he finds valuable. We've got Mark Stignani, also from Schwegman, and Mark is the chair of the Schwegman Analytics group. And Mark was a former chief patent counsel at Thompson. Mark does a lot of analytics work for our customers and also is very familiar with patent analytics and examiner analytics. We've got Tom Marlowe, who's the president of renewals at Black Hills IP and also manages their analytics technology, which includes Patent Buddy and then also Black Hills IP's renewals analytics. And Tom is former chief patent counsel of Fairchild Semiconductor, also was a patent attorney in private practice for a number of years. Tom has tremendous experience. And last but not least, or best, but I guess, is we've got the Russ Slifer, who's CEO of Black Hills IP and former USPTO deputy director. And so we've got some really great perspective here. We've got the patent office perspective. We've got, the private practitioner perspective. We've got, a corporate practice perspective. So we hope we can get through. There's a lot of material to cover today, and so we're going to jump into it head first and see what we can learn. So if we can flip to the next slide. So everybody knows what examiner analytics are, so I won't waste much time on this, but essentially it's any data that you can collect that shows essentially statistically how cases are handled by art units, examiner, the patent office as a whole, and down at the examiner level as well. So there's multiple different levels of analytics that we call examiner analytics. Next slide. So we're going to learn today, who uses examiner analytics, when they're used, strategic insights, different types of analytics, how they're generated to some degree, and then a little overview of the tools. Go to the next slide, please. And some key uses of them, cost projections, outcome management, art unit targeting, appeal versus RCE, continuation decisions, new application targeting, and then the typical users are the corporate and the law firm. And as we start the program up, I just want to put a preface on this that, and we'll discuss that at length in this presentation, or it'll be mentioned a number of times, is the analytics, examiner analytics in particular, are very complex in the sense that it's difficult sometimes to really ferret out or separate out the different influences that go into examiner analytics. And so just at the start here, I want to mention that I think anyone that uses examiner analytics realizes that some of the analytics that might be ascribed to an art unit or an examiner are driven by PTO policy and in terms of like a 101 policy or other policies that might influence the availability of patents in certain areas. So I just want to be clear also, there's influences as to some examiners get the tough cases because they're extremely proficient in a given area. And so that can influence. So there's a lot of different things that go into influencing these analytics. And I want to just have a disclaimer up front that nothing that we're going to discuss today should be taken in any way to be critical of any particular examiner or particular statistics, because they're all mainly driven by factors outside of the control of examiners. So next slide, please. Do you want to take it from here, Mark, and walk through this a little bit? Stigani? Mark, I think you're on mute.
Yes, my keystroke didn't quite let me unmute myself. Sorry about that, everyone. Yeah, so examiner metrics that we can play with here. I mean, I think one of the most underutilized aspect of examiner metrics is the financial statistics. That if you look at an examiner's predilection towards office actions or amendments and that sort of stuff, you can help understand, advising your client and maybe the cost to prosecute with a particular examiner. You can look at the company statistics in various art units. They have success rates in that you can look at, competitor success rates. Also, the law firms have various success rates when we're looking at examiner metrics. I think those are very large holistic views. And when we start down to get into the examiner stats in particular is when I think a better estimate of financial investment can be given. You have stats around office actions to allowance. We'll cover a lot of this going through rather than just kind of read through this, but we also like to look at, basically when during the period of a month or when during the quarter, an examiner might be more, statistically inclined to put something forward into allowance and those sort of things. So there's a lot of qualitative analysis that we try to put into this that stands on top of the data itself, so that we try to be as intellectual about how we apply those knowledge points as possible. Next slide, please. And so what can it tell us and what can it not tell us? I mean, generally the tools we use show us the success and abandon rates, the pending rates, the aspect around the examiner's professional background. And then we can look at, what time during the month that they may, be inclined towards allowance and when they wouldn't be inclined towards allowance. I mean, there's, examiners are under a level of, production urgency to get through their cases. And so that needs to be taken into your thought process as you're bringing this forward. Can also find whether you want to, go into appeal versus an RCE. Does this examiner have a good record with pre-appeal conferences? You can look at all these various things, and then from that comes out your budgeting and prosecution decisions. So what we really can't tell is the qualitative aspect, because within the patent office, as Russ will probably say much more eloquently than I can, there are a lot of things that mess with those statistics so that they aren't really a full and true disclosure of what's happening. And so just at the bottom, I really want to put the caveat forward. We do not recommend in any way discussing examiner statistics with the examiners, because in my research there have not been a lot of successful cases where this has been a useful ploy. So really overemphasize, this is something that you use internally as a budgeting tool or a success tool. Next slide, please. So what do we find useful? This is much more of the, what we just read off the chart versus, what we put more effort into, so on the qualitative versus quantitative side. So we like to compare our units versus examiner, just to see if there's an outlier, an examiner who's an outlier, or is the entire art in alignment there. Success rates of office actions. So, how many office actions does it take to get to an allowance? Is this examiner particularly interested in, giving office actions up into a certain point and something comes out of it? What are the interview success factors? Are there, is an interview early better? Is an interview later better? RC counts, extensions, all these various things. Also, we like to see what types of things policy-wise are happening. So when we look at the rejection stats, especially 101 in the software arts, I mean, that tends to show as much policy in play as much as the subject matter itself. So we'd like to try to look at those stats quantitatively first. Now, when we're giving advisories to the client, and Garrett will certainly cover this much more eloquently later, but we like to try to give cost to grant or cost to continuation discussions about when we have a particular examiner in mind. We can use that as a buffering factor or a fudge factor where we say, well, the cost is here, but since you've got a harder examiner, we might want to budget more to put a cost to this one. Or if you have an examiner that runs up the RCEs and office action company, you may want to think about what claim coverage you're going to get in that perspective. Again, these are all just vectors. I want to make sure we reemphasize these are vectors and not absolutes, because we treat them as absolutes, and many times they will become self-fulfilling statistics, and we don't want to go there. So again, we also like to advise allowance rate versus claim scope, and also if there's a competitor impact, is if these examiners are working on competitor matters, just to look at how those examiners have worked with the client's competitors as well. Anybody else want to jump in here, because I don't want to.
Yeah, Mark, one of the ways that I also like to leverage this data is to look at it statistically across like a portfolio. So this is if you're kind of in a portfolio management type of a role. While the single case data is certainly interesting on a matter by matter basis during prosecution, when you compile this data statistically across a portfolio, you increase kind of the overall maybe accuracy or usability of some of those projections, which then can drive into budget forecasting, portfolio-wide grant estimates, success rates, that type of thing. And I know we're going to talk a lot about kind of a single case analysis, but as we're going through, it's worth thinking about for the audience here, what we're talking about on a single case basis. How can you extrapolate that out across a portfolio to get some ideas about what's going on within a portfolio that you're managing?
Yeah, thanks a lot. Anybody else want to jump in here? Otherwise, and I also want to open an invitation to the rest of the audience here, is that we do like to take questions contemporaneous as we're going through this. So please, use your question and answer bar if you have things that we're not covering that you would like to answer further on. Let's go to the next slide. So Russ, could you take us through kind of the PTO perspective?
Sure, and thanks. You mentioned a little bit ago, Mark, about looking for outliers, and I think that's important to keep in mind here. The tools that are available for extracting this data and putting it into consumable content for analytics have some variability between them, but also the examiners are important to keep in mind. The Patent Office has more than 8,000 examiners spread across technology centers and then subdivided into art units. And there's probably more than 600 supervisors of varying degree of expertise supervising those 8,000 examiners. They go through training, but a lot of the training is an apprenticeship type training for quite a few years of their career. So as they're gaining both experience in examination, handling the workload, cases being transferred between examiners being moved around based on the demand of the art unit, obviously technologies age, and so new technologies require examiners to move from the old technologies to the new where the applications are. But then you layer on top of that changes in the law and training, even policy changes from administration to administration. So you might have a heavy emphasis on, let's say, 112 training. And that training is going to roll out across the different art units at a different pace. They're not all going to get trained simultaneously. So there's a lot of variables in the background that this data isn't going to reflect very easily. So looking for outliers, looking at the macro level of an art unit, TC, how particular classifications of applications, from the as they're classified, they obviously get assigned to certain areas, but you can look at how those are being treated, whether it's 101 and that will, I think, help the user of this data get some general ideas and understand, are we in the middle of the bell curve? Are we dealing with some outliers? And finally, I'd say, don't make the data self-fulfilling. So if you're looking at some examiner information, you're looking at on the micro level on the examiner, and you realize that he or she does not allow very many cases. You might go into prosecution or an interview with that examiner assuming that it's a lost cause, and that may become self-fulfilling. So it's good to have the knowledge, just like before a judge, of what their past decisions have been, but don't make that become what their future decision is by your behavior.
Thanks, Russ. And to that end as well, I think that you can certainly use the statistics to help. You may say, well, maybe we don't like, this examiner doesn't like RCEs very well based on the performance, and maybe go direct to appeal. But again, always look at things kind of in the larger case versus looking at small quantities of any statistics, which may give you a misaligned approach. We just got a question in, and I think I'll toss it to Russ first. Statistically, we know that examiners with long prosecution histories have more data from which to draw prosecutorial decisions. How do we gauge decisions working with a relatively new examiner? And if you can kind of give how the PTO takes care of its new examiners, Russ.
Well, it's a good question, and this gets to understanding how examiners are trained and move through their career. A new examiner obviously is going to enter into the PTO's training academy, where for 6 months or so they're going to be trained on the basics of examination, but always under the supervision of somebody. So while you might see the examiner's name on things, really they're not the one making the decision. They're doing the behind the scenes work on searching and making a recommendation, if you will, to their supervisor. And that's actually going to continue while they're an examiner until they achieve the level of proficiency, whether they're going through partial signature authority, which means they've demonstrated competence to a level where they're trusted to make certain decisions on their own, but still supervised by a primary, or after quite a few years. I don't know, it varies how many years it takes, but probably close to 5 of being an examiner before you're going to be able to be proficient enough to reach full signature authority and become a primary examiner. So you can look at the the experience, the tenure and the title of the examiner. Once you get to primary, I think the statistics become much more accurate because there's less decision makers involved, and it pretty much comes down to that one individual.
Thank you. And I do know that I'm able to pick out SPEs, or the supervisor examiners in a unit, and look at their statistics as well. So I would certainly encourage people looking at a new examiner to also look at essentially their coach and how they might do stuff. Steve, hand it back to you. Do you have any additions here?
No, not particularly. I mean, I think Russ covered it, and I can tell a quick story, and then I think we should jump into, maybe we could jump into Garrett's presentation, but just to kind of tee it up, there's a couple different things that happened, over the years. And I remember one was, I think it was during the most difficult period of time with 101. And I had a case in front of an examiner, and I didn't have any examiner statistics to look at, so I wasn't looking. But after a long prosecution, I got the case allowed, and I got on the phone with the examiner for some last minute, changes. And I asked the examiner how it was going, and she said, well, this is the first case I've allowed, and I've been here like 2 years. So I think, to Russ's point, don't assume that just because there hasn't been an allowance from a given examiner, don't think that you can't be the first one. And the other one is just an experience I had where one of our lawyers had a case, and they got a 101 rejection, and it seemed like maybe not that, pertinent to the technology. And rather than sort of get worked up about it, we went and looked at the examiner statistics and realized that it was probably a pro forma, it was a 101 given according to policy, and that that they should give a response, but, not assume that this was, going to be a roadblock. And sure enough, that case got allowed. So I think, there are uses for this that help a lot in judging, where you're at in terms of with any given examiner, that don't cast any negative aspersions towards whether this person's difficult to get a case through. It's oftentimes that's not really that relevant. But with that, let's go on to let's see some stats that we've got. And you want to take it from here, Garrett?
Yeah, thanks, Steve. Sorry, it just took me a second to unmute there. So what we have here is in the next several slides are some examples of the analytics that we've been discussing. The particular slides I have, the analytics come from a tool called Patent Bots. I know there was a Q&A about that, but another tool I've used is called Examiner Watchdog. And since I started to use Patent Bots, have kind of gone away from that, as I sort of like the way Patent Bots looks. But what we've got here is just sort of a executive overview of a particular examiner, just a top-level review that provides the 3-year grant rate and a couple of sort of difficulty classifications here. So, in terms of the difficulty, it's not to say that any one examiner is a difficult person or not reasonable. It's really just based straightforward on their 3-year grant rate compared to the 3-year grant rate of all examiners. And as Mark, Steve, and Russ have all mentioned, there's several influences that can kind of affect the grant rate of any given examiner. So looking at them as a whole compared to the whole pool of examiners isn't always the best, or at least most determinative signal, but you can at least start to get an idea of the type of examiner that you're dealing with when looking at this. And I do find that the 3-year window of grant rate is helpful. It provides a nice window over prosecution. I think some of the other tools I've used provided a grant rate, but didn't really provide the time period over which that was calculated, and was never quite sure how they came about that. So as I mentioned, there are several influences. So it is often important to not compare it to really necessarily all examiners, but to but specifically to examiners within that same art unit. And so some of the subsequent slides will get to that. But just a quick note on this particular examiner, and this is somewhat related to Steve's story. So this particular examiner I started working with quite recently, and the examiner has examined several cases for a single client that I work with. And I got several of them at the same time, and I looked at each of the office actions, and they all had, multiple 103 issues or 112 issues. And so I started to think, oh man, this is going to be a challenge to get these claims allowed. But then I opened up Patent Bots and took a look at this and thought, well, maybe there's something more to it. It doesn't seem like it's going to be quite the challenge that I had anticipated. Perhaps there's something more here going on, and you can see this examiner's over the the 3-year period, they've got 303 cases. So this is, a very very experienced examiner who, does seem to be willing to grant allowances to many of her cases. So if I could get you to change the slide, please. So as I mentioned, it's definitely important to look at the other examiners within a single art unit, because then within the art unit, there's probably a more comparable implementation of certain policies and probably equal amount of influences. So that's sort of what we have here on the right, the comparison of the grant rate with others in art unit 2851. So this is the same examiner from the previous slide in art unit 2851, which examines mostly sort of hardware inventions, circuitry, and to the extent that they sometimes examine software, it's related to electronic design automation. So, very strong ties to hardware and circuitry, and likely not a lot of issues here with 101 subject matter eligibility. And so you can see, the examiner, though in the previous slide was, very, very easy, 13th percentile. Really, this examiner is pretty on par with the rest of the examiners in art unit 2851. You can see that the art unit itself has an 87% grant rate over 3 years, with this examiner being just slightly below that at 86. And then you can, of course, compare that to all of the USPTO, which has about a 68% grant rate. And so the art unit comparison is also provided with this grant rate timeline here. As you can see, it sort of breaks down how the applications this examiner has examined sort of fall over time, and also provides some sort of waypoints or indicators of these prosecution events, particularly RCEs. And so this sort of goes back to Mark's point on the sort of the predilections of some of these examiners, as far as maybe requiring a greater number of RCEs. So I often use this and as well as these other statistics as a bit of a level setting or expectation setting mechanism for not only clients, but myself as well. And that's in terms of budget here. You can kind of point to and see what you might expect on an average case with this examiner in terms of the number of RCEs you would need to file. You can see 50% of this examiner's cases are allowed after just one RCE. And another thing that you can use this to advise clients is, you can see after the second RCE, there's not very many cases that are getting allowed. So you can kind of see that if you've gotten to the point where you're needing to file a second RCE, there may be not a lot of benefit in putting forth that money to do so, because the likelihood of getting a allowed case at that point, it becomes a lot lower. So again, just very important in terms of budgeting and as well as expectations as far as how long prosecution is going to take. And so I also have another slide, if I could get you to switch. This is the same sort of information, but now with a different examiner. We had a quote, very easy examiner in the previous slide. And so this is just a separate example, same information with an examiner who has a much lower grant rate over the 3 years. And in fact, as you can see, this examiner has a 0% grant rate. But when you compare that with the art unit of this examiner, you can see he's not far off from the average of his art unit. And in fact, this art unit is a very software heavy art unit. I think they are one that often examines so-called business methods, or at least computer implemented business methods. So they're running up on a lot of the 101 subject matter eligibility issues. And that's, I think, reflected here in these statistics. And if you look again back to the grant rate timeline, no green here, because this examiner has not granted any patents. So, and you can see a much steeper sort of decline there, where you have a lot more cases being abandoned by the second RCE. And another notable difference here is that time between first RCE and second RCE. So it looks like that amount of time it's taking the examiner, or possibly the applicants in this case, trying to make decisions to respond. And so there's just a bit of a delay there compared to the previous examiner. And so this particular examiner I wanted to include because it was really the impetus for me to start to look at these statistics. I started working with this examiner, or in fact, I haven't worked with this examiner in several years, but several years ago, or actually around the time the Alice decision came down, I was working with a client who was involved in in e-commerce. So they of course had a lot of 101 issues to deal with, and this examiner in particular, it was just very, very difficult to come to any sort of point of agreement in terms of what might be eligible subject matter. And in fact, the examiner was doubling down with 112 paragraph 6 rejections and pretty much any rejection the examiner could find. So it was very clear it was difficult, and I wasn't quite sure what was going on. So just wanted to gather as much information to really try and figure out what was going on. And so that's really where I found these examiner analytics. However, at the time, and this goes to I think Russ's comments as well, the examiner was fairly new. So the statistics for this particular examiner at the time, he only had a couple of cases, and so it showed that at that time he had a 0% grant rate, but pretty difficult to really pull anything from that, given the number of cases he had actually examined was quite low. So part of the reason for including this slide was just to make a note that it's always important not only to compare to art unit, but also to look at the raw numbers themselves, because if we are dealing with a new examiner or someone who has very few applications examined, the statistics provided for them are probably not very determinative of the actual outcomes that we're going to see with them. And so in those cases, and as we did here, we relied more so on the art unit statistics. I think the assumption is that a junior or a new examiner is probably not going to get to the point where they're an outlier, and so they're probably going to be fairly closely aligned with their art unit statistics. And so based on this art unit statistics of a 5% grant rate, at the time the client and I devised a strategy where we were trying to basically get the case out of this art unit. So we had filed a continuation with some different claims and a different title to try and get this reclassified and placed into a different art unit. And we were actually successful there. The case was later transferred, so I'm not sure if the case, we ultimately got an allowance there, but we were at least successful in getting this to a different art unit that likely had a higher grant rate, given that 5% is probably one of the lowest grant rates in the PTO.
So Garrett, just to interject here and highlight before we move on, this slide I think is important when we're talking about what I said: policy, legal changes, training. I would expect new examiners, as they're being trained and supervised, to, as you said, conform more closely to what the art unit as a whole. If you've got an art unit in a fairly steady area like you had on the slide before, that's getting close to 90% allowance rate in a mechanical or electrical area, I would assume that new examiners, as they're being trained, are going to be closer to the median there. Where here, certainly in an area where all of the examiners are dealing with the changes in 101, afraid, frankly, to make allowances, not knowing, the courts were invalidating everything that was getting to them. You would certainly expect more junior examiners to be even more concerned and end up at or below the statistics. So looking at the macro, I think, is important, but taking it as understanding the entire ecosystem is important too. Thanks.
Okay, yeah. Thanks for the comment. And just one last comment on this one before we go to the next. I did mention, when I initially looked at this, that the number of cases was rather low. This is actually very recent now, so this particular examiner has had 5 extra years or so to examine cases, and still the examination rate is at 0%. But I don't know if that really qualifies this examiner as an outlier. I think again that the important thing here in terms of advising a client or setting expectations is probably that of the examiner's art unit. Any number of, there's probably only a couple of cases that have been allowed in this whole art unit. So, it could be just merely coincidence that those didn't get provided to this examiner. And I'm sure there's other examiners in this art unit that also have a 0% grant rate. And so if I get you to change slides, please. So this next one, and as well as the slide after, are some of the probably more practical slides that I rely on a little more heavily. The general, I think, agreement among practitioners is that examiner interviews are beneficial to a case. That there is some benefit in terms of the likelihood of achieving allowance that's gained from having an interview. And what this slide shows, and what I've seen most of the time, is that the statistics really do support that. So here, on the left, it's simply the grant rate without interview, 85% for this examiner, and then grant rate with interview is 96%. And then I like the chart there on the right, which is really just the interview benefit, and they compare that with not only the art unit, but the PTO itself. And so this examiner, essentially you have a 13% improvement in your likelihood of achieving an allowance if you interview, whereas the art unit, it's actually only at 2%, but it is in line with the sort of PTO average of 13%. And I don't find it's often the case that clients need justification for conducting an interview, but should the need arise for you to justify that, I think oftentimes you're going to get support from the statistics here. And if you're looking at a 13% chance, or an estimated 13% chance in improving the likelihood of allowance, I think it's definitely well worth the cost of an interview. One thing that's not shown here that's an interesting trend that I have seen at times is where there's actually a negative benefit, which would seem to indicate that there might be a bit of a detriment in conducting an interview. It's I think hard to make any definitive conclusions from that data, given all of the different influences, and also again important to probably look at the raw numbers there. But I have seen it on more than one occasion. And I think that there could be some explanations for it that might provide a signal to help start to tweak strategy. That being perhaps some examiners are better at or prefer written communication over verbal communication, or perhaps some examiners often in verbal communication end up in getting confronted by an attorney and perhaps digging in their heels. So there has been a couple occasions where we were deciding whether or not it was appropriate to interview. I noticed that there was actually a detriment in conducting an interview, and I brought that to the client's attention. And so we had decided in that case just to go ahead and forego the interview, forego the cost there, and let our kind of response stand on its own. So just an important thing to note there. Okay, next slide, please. So these next two slides are about appeals, and really in terms of, I mentioned these statistics, I often use them for mostly expectation setting, whether myself or with clients and advising clients. These sorts of statistics are actually where start to use them in decision making, or at least as a signal to help with the decision making, and that would be the decision of whether or not to RCE or to appeal at final. So you can see in this slide, this is a breakdown of appeal outcomes. Good outcomes being where the examiner was reversed or affirmed in part. A neutral outcome being where prosecution was reopened, though I often consider that a good outcome as well. And then a bad outcome where the examiner was affirmed. And so important to note that this particular chart is a breakdown of all instances in which an appeal was filed. So this would include both pre-appeal brief conferences as well as PTAB decisions, but you can look at the breakdown of PTAB decisions and pre-appeal decisions as well in a similar manner. And based on discussing this a bit with Russ, actually the pre-appeal decisions may provide a bit better indicator of the quality of examination up until that point. But I find all pieces of that important in the decision making as to whether or not to appeal or RCE. And really what I look at is how often the examiner, how often we have a good outcome, how often the examiner is reversed. If you're seeing an instance like this where the examiner is reversed 100% of the time, it may be a good indicator that if you find you have a good argument against the rejections, it may be a good time to appeal. However, if you do look at this a little closely, we only have 2 decisions that we're comparing here. So, probably not the best indicator, but really what this is indicating to me is, there's five appeals, only 2 of which have outcomes for comparison. So people are really just not appealing with this examiner very often. So that may indicate to me that an appeal is not a good option, and that we could probably work with this examiner to achieve allowance. And when you look at that in view of the grant timeline, I think that those 2 things would definitely align. So this next slide is, if I could get you to change that. This next slide, same information, but this is back to my difficult examiner example. And also to provide a bit different look here on how these statistics could stack up. So here, this examiner has had 13 appeals, 5 of which have outcomes for comparison. And so you can see of those 5, 60% of the time, which really is only 3, the examiner was affirmed, and only 1 of those 5 was the examiner reversed or just affirmed in part. So again, though it may be difficult to achieve allowance with this particular examiner, it's not very reflective of necessarily this examiner's reasonability, given that the PTO often agrees with this examiner. So it may more so be an issue of some of those other influences we talked about in terms of their grant rate, where they're dealing with 101 policy for cases given their classification that are just going to struggle with subject matter eligibility. And I think that the appeal statistics here probably agree with that. And so in this case, despite the challenges in dealing with this examiner, probably would advise the client not to appeal, because the likelihood of success seems fairly low, which, as I mentioned before, that we did not appeal. We actually filed a continuation to get this one out of this art unit. So, and so that's it for me for my statistics, and I'll kick things back over to Mark.
Great, thank you very much. Before we go into that, I think I wanted to interject in a couple of the questions here. Tom, there was a question around the XML version of office action and so forth and so on. Do you have some insight into that?
Yeah, absolutely. In fact, the question is pretty timely because relatively recently, the USPTO opened up a pretty slick tool called their Patent Center. And I'll put a link to that in the Q&A section for this question. But in the Patent Center, which is basically like a better version of public pair, it's used for other things as well. And I think the plan is for it to ultimately replace the current views of public and private pair. But I would go check that out. For anything, I'm not sure how far it goes back, but I just checked on a matter today, and you can go in and get the DocX, PDF, or XML versions of Office Actions from there.
Thank you so much. So my section is really about looking at kind of the long tail of examiner analytics. So as Garrett was showing earlier, we have the tools show a 3-year look back. That tool is PatentBots. Patent data is also available in a number of other tools. Just off the top of my head, the Acclaim tool from Anaqua, Patent Advisor, Auto Retech, which is little red-headed stepchild of LexisNexis, and then I think Ethnography also carries some of this data, although I haven't looked at it deeply. So what I do though is I'm trying to look at art units and pivot around art units and examiners in light of things like assignees, and we're looking for things of consistency and things that would help us understand. So I'm going to pick an in-between example here because I think these are probably the harder ones to work through analysis with. So as you can see here, this is Art Unit 3665, which, you know, really for what's more notable about them is that they are the Art Units doing a lot of the good review of autonomous vehicles. So yeah, in this thing you can see that, you know, most of the major car makers are represented here. You've got IBM, you've got Honeywell, you've got a bunch of other you know, high-tech companies in this playground. So what I try to do is I look for consistency in how an art unit is treating various assignees in this subset. And this is you know, relatively, you know, non-polarized version. Looks like everybody's getting relatively the same treatment. So if you move to the next slide, then I would look to, when I'm looking after I've looked at the art unit first, I look down at the examiner level. Now, this particular examiner has a couple interesting, you know, generally lots of pending cases here. So that would, without looking further, maybe make me make the assumption that this is a new examiner and doing, you know, relatively young work under you know, a SPE or something like that. It's actually not the case. So one of the things we can tell from these tools we use are, you know, how long the examiner has been with the organization. And so what we can do here is figure out that this examiner has actually been an examiner for over 10 years. And so there's another reason for why there's a large pending load here. And we'll see that in the next couple slides here. Next slide, please. So this is a slide that looks at the examiner and said, look, well, it looks like the examiner's only been working, you know, in the last 3 years in this area. And that's true. This examiner has been switched around at least twice, two other art units, so that this examiner has, you know, it looks like you know, has developed a specialization to the point where they can float him to other office units. And, you know, Russ, if you have any thoughts on, you know, kind of the rotation of examiners into different art units, please join in. But this, you know, pretty much shows you this examiner's, you know, been brought in to handle surges in this particular art unit. Next slide. So, and then in general, we want to look at the, you know, general annual art unit performance. And so, again, we're looking at consistency here. We want to make sure the art unit is not particularly, you know, heavy-handed in one way or the other. And it looks really, what we're looking for is goodness outliers, but we can just see, you know, generally how these art units have been surging, you know, in the area of autonomous vehicles and other robotically, you know, driven items, either in transportation or other industries.
So, and then Mark, I'll just interject. So, you know, part of what this slide shows us is that there's a lot of stuff still in process at the end, but, you know, pretty much it's been a consistent percentage allowed up, you know, all along the way, right? It looks like it.
Yeah.
Yeah.
And so, you know, there's uniformity. Go ahead, Russ.
Yeah, this is kind of what you'd expect from a new technology. You know, at the beginning, everything looks new. The amount of prior art is small. You're going to see more allowances. And then as the technology develops and it starts turning into incremental improvements and more players in that area as the volume went up, obviously, then you'll start to see more differentiation between things that are being allowed and taking longer time to prosecute. So you'd expect something like this, and then, you know, take this out 10 or 15 years, and then you'll start to see the bell curve coming down again.
Absolutely. And so, you know, also, you know, it's just interesting things you can see from a simple slide. Next slide, please. So now we're going to kind of dive in comparing one versus the other. So we're looking at, you know, top level. The top item is the examiner statistics and the art unit statistics. And this art unit and examiner largely agree in much of their activities here. I think that this examiner, you know, from, you know, time from start to finish in allowed or an abandoned manner is within, you know, statistical deltas of the art unit itself. So there's no outlier in that respect. And the amendments required on an allowed grant from a published app also very similar with respect to it. One of the interesting things I found that allowed grants on average across many art units, tend to be about 200 to 250 words. I mean, I think it's an interesting statistic that a lot of the amendment statistics are not tremendously differing, even from a really difficult unit to an easy unit. So it's just a quirk of the data that I'd like to comment on. Next slide, please. So this is one where I like to work with, kind of in cost calculations. So office actions to allowance or amendments to allowance. So this is a relatively useful tool in kind of, starting to estimate, how many times you may have to, pay for an extra office action or an extra item. Now the examiner by itself is, he doesn't allow anything on the first office action in this art unit. Let me be clear on that. Whereas the rest of the art unit is also not tremendously easy to get through on the first office without first office action allowance. So the fact that we're dealing with highly complex technology as a modifier, since a lot of robotics technology has been well patented over, since the 80s, in fact. So a lot of this is trying to find the nuance of novelty and the nuance of not obvious to get things through. So again, also take that into account. But as you're seeing here, you can start seeing the budgeting process of cost to allowance, where you can say, well, the cost to allowance on this particular examiner is going to be, probably one office action at least, and we're probably going to have at least one or two amendments on the spec, and that then tends to comport with the rest of the market, the rest of the art unit, in its own amendments to allowance. So again, as you're reading this slide, the top line is the examiner specific analytics, and then the next one down is the actual art unit itself. Please move the slide forward one. And so, and as Russ and Garrett have talked here, we'd like to look at appeals, and but also one of the items that we don't have a slide for, but I certainly want to let you know is about there, is that the pre-appeal conference decisions is another area that I think is well worth reviewing on. This examiner, again, has very few matters that have gone through pre-appeal conferencing as recently. He's only done one, and it didn't go well. So, so as we're going through this, we want to look at do we go to RCE, do we go to appeal? And in this case, it's kind of 50-50 in this respect, because you probably have a 50-50 chance of winning an appeal if you're appealing by the applicant side. But on the RCE side too, he tends to, I think, do well. You're doing well at least on the first RCE. And if you look at the rest of the art unit itself, that pretty much follows the same trend, even though this examiner has smaller numbers. Next slide, please. So when we talk about interviews, this is an interesting item as well. So we can go back a bit deeper into the examiner interview, because I'm able to parse by whether an examiner has initiated an interview or an applicant has initiated an interview. And those statistics, I think, are extremely telling by examiner. If an examiner doesn't do a lot of initiation, and I looked 10 years back into this examiner, this is just his art unit 3665 there. But he has a history of, in his entire 10-year career, he's only initiated 7 interviews. So it's a good nuance as to how receptive this examiner is to receive an interview. And in the case of applicants initiating it, he's okay. He's okay with it, but doesn't seem to have an awful lot of interest. So it's a fairly low number for this particular examiner. Whereas the art unit, I think the art unit has a history of opening itself up to interviews, with the examiner's initiating at least half as many as that the applicants have. So again, as you're thinking about when and how to interview this examiner, you also might want to look deeper into this examiner's details as to when these interviews, when a good interview happened. What week did it happen? Was it right before the close of his metrics, or during the other time? So you can start to see trends emerging in these examiners' behaviors.
Oh, hey, Mark.
Yes.
Just an observation on the slide.
Yep.
I would assume that the abandoned interviews are a call to confirm the case was abandoned, and that they show up in the slide.
I think this was just whether the case ultimately abandoned or ultimately allowed. There wasn't
okay.
There wasn't a call to abandon in this. So sorry I wasn't clear on that. So yeah, I think there's an awful lot of additional levels we can look down here. I mean, this is, we're getting close to the end here, so I want to save time for any follow-up questions. So let's move to the next slide. And the key takeaway, at least from my part, and I'll just stop there, is that examiners are doing a hard job. They're doing something that requires a great deal of effort and focus. And putting them down as a statistic is, I think, a disservice until you look much deeper and much more qualitatively what's going on with that. So that's my predominant takeaway here, and I'll open it to the rest of the team.
Russ, did you have anything you wanted to add to that?
Yeah, I think we've been pretty clear on it, but examiners are humans, and humans do have patterns, even though examination is difficult and very subjective. So using this data, I think, helps remove a little of the unknown dealing with a large government organization and shall we say, a faceless employee at the PTO. But it has its limitations. It helps inform, it helps you understand why you might be having difficulties or why things are moving easily. And it helps to share that with your colleagues and clients. But it can't do everything. It's not a crystal ball. It's not going to predict exactly how you're going to fare, because the quality of the invention, the quality of the application, the quality of the attorney, all of that plays into it in addition.
If anyone else has anything.
Garrett, do you have any final thoughts you want to throw in there that you?
No, I think Russ put it very well, so I'll just leave it with what Russ said.
Sounds good. And I guess we'll just finish up by, if there are any examiners online, thank you for your work you do. We appreciate it very much. Of course, we're very biased in terms of what we consider a good examination. All the good ones are allowances for us, and all the bad ones are rejections, but that's a joke. Anyways, thank you very much, everybody, for attending, and we'll see y'all in a couple of weeks. Michelle, what's up next?
Sure. So coming up on June 4th, Greg Rabin is having a webinar about artificial intelligence. And then the next patent analytics webinar will be coming up on June 11th. And thank you everyone so much for joining us.
All right.